All right, good evening, folks. Welcome to Monday Night Law on Kirk's Law Corner. Hope everyone has had a wonderful weekend and everything was good for you as it was for me. A little cold here, but it's starting to change a little bit. Welcome to Idaho weather. Almost kind of looks like we're having a little bit of an issue over here. On Facebook. Let me refresh that and see if we're doing okay. Okay, I think it's all good there. All right. Thank you all for the support. Thanks for being here. Knowledge is power. It literally empowers us. So the more we can get here to learn and get this knowledge, the better off we're going to be. All right. So I want to thank all the supporters out there supporting to pay the bills here. And those of you who'd like to help continue to support, that would be greatly appreciated. And those of you that are new, help support the channels, pay the bills. Them postal money orders, regular money orders, cashier's checks, cash wrapped in aluminum foil, any gold and silver coinage, greatly appreciated. Send that through the snail mail over to the office, 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. And for the digital side, PayPal is Kirk_Pendergrass@hotmail.com. My Cash App is the $, capital K, capital P, EN71. And for those who'd like to join me over there on Patreon for the reoccurring monthly support, as well as private Zoom meetings on Wednesday night workshop. And wasn't a whole big turnout this last Wednesday, but I know we had changed the time there at 5 p.m. Mountain Time, 4 p.m. Pacific, 7 p.m. Eastern, so that other people could actually make it in there. So change of time on the Wednesday night workshop. And again, eventually here it's going to go to just tier 3 and tier 4 available for the Wednesday night workshops. But in the meantime, right now, I'm leaving it open to all patrons on Patreon. And that's patreon.com/Kirk's Law Corner. And then, of course, over there on the website, kirkslawcorner.com, for anything that happens with either of these channels and nobody knows where I went and how to get a hold of or find me and videos and that stuff. You'll want to check your kirkslawcorner.com. You can also sign up to be on an email list for anything like that goes down. We could send out an email to let you know what's going on there. But hopefully that doesn't mess too many people up. But anywho, I want to just thank everybody for the love and the kindness and the prayers, which is greatly appreciated. We all need that. And again, thank you all for being here, wanting to learn. Now, I left off with going over the commentaries on the Constitution by Joseph Story. It's a pretty good read, a very powerful book to cite from. Again, everything is about knowledge. Knowledge literally empowers us. I can speak firsthand, me 26 years ago, not having a whole lot of knowledge, but over the years, I've gotten experience, right, from being unlawfully arrested, kidnapped, deprivation of rights while acting under color of law, right? Color of authority. Um, having this experience sometimes isn't the best experience per se. A school of hard knocks to a certain extent. So, this is what drove me to start studying the law back in 1995, was because of what I went through and experienced, the corruption and the manipulation. Take this plea bargain or we'll go to trial and I'll make sure you lose and you get the maximum penalty. And you go to prison for your full time. Even after I'd already proven the police officer did not have probable cause to make the arrest or stop. I did that all by myself off the top of my head, knowing basic common sense in April 19th, 1995. Some people say, oh, he's never won anything. Oh, I've won quite a bit. And at this particular point, I'm by far winning more often than I'm losing, especially in my own personal things, as well as there's many things that I've done to help other people that have never gone to court, that have been defeated on the spot at the time during the instance or event, transaction, occurrence, and event here. Not everybody's privy to that knowledge. Not everybody knows about that. But those that I have helped know. So believe me when I say that I've got this experience, because I've lived it and know about the corruption. And again, this is the reason why I started studying the law. And absolutely right. Everything happens for a reason. It was meant to share this info. Think about it. That's it. Because of my experiences with corruption, I felt compelled to do something about it, and I'll give that credit to Carl Miller. Watching through his videos, and he just basically put it point blank, blunt. Oh, somebody ought to do something about that. Be a somebody. Well, I'll be darned. And to quote Edmund Burke, the only thing for evil men to prevail is for good men to do nothing. So it just makes common sense to me that if you're going to do something, you're going to have to learn how to do it. And I get that studying the law, learning the law is a lot to take in. And so I try to tell people, well, look, I've done a lot of the hard work. I've done a lot of the research and found the stuff that we need to be reading and comprehending. And, some of it I've broke down in my educational series. For those of you who have not seen the educational series, both on Facebook, YouTube, and Patreon now, there's 8 episodes in a playlist called Educational Series. So if you go Facebook or YouTube and you go to the videos tab, and you see the word playlist there. So go to the playlists and you'll see the 8 episodes in the educational series, both on Facebook and YouTube. Watch those as many times as you need to. Go to kirkslawcorner.com and download the books that I'm referring to in there: the Treatise on Arrest and False Imprisonment, the Authority of Law, Mason's Manual of Legislative Procedure. Okay, they're right there for you to grab and download and follow along in those videos. Okay, and things have been quite busy here in Idaho with my team and I, and dealing with what's going on in the legislature, as well as taking on the whole thing of the state of emergency in the state of Idaho. And like I've tried to explain to people is, I'm working in Idaho now, specifically, and in Idaho only. Okay. This is what we've got to get local. We have to, I can't be running around all over the United States of America trying to help other states when I neglect my own. So, again, those of you that are in Idaho that may want to do something, be a somebody, and want to get actively engaged and involved with education. You're gonna have to learn this stuff. This isn't something that you can just go, oh, I can do that, and not have any knowledge, not have any power, and not know how to wield that power, But I could definitely use more people in Idaho to start standing up and do what we're about ready to do. And it's going to be huge. I'm not joking. I've already been down and talked to the lieutenant governor here a week ago, Thursday. And as far as I can tell, it's already starting to spread like wildfire down at the legislature. There's some things that are already starting to go, oh, wait, I think I want to withdraw my bill. I've warned them that we're providing oversight. We're done with the tyranny. It's go time. It's time to start telling on these people and removing them from duty. Ignorance of the law is no excuse. I've tried telling these people they don't have subject matter jurisdiction. That's not how we make law. And I keep getting well, then why don't you just do something about it? Well, I'm going to. But I tried talking to certain people who I thought were conservative Republicans, or whatever we want to call American patriots, is what I really was in my mind. And say, look, you guys don't have the authority to even make legislation regarding this particular subject matter. And they just don't get it. And I don't know what else left there is to do. I've tried to educate these people. I've tried to warn them to stop doing what they're doing. I've refrained from really doing much of anything about telling on these people, because they're all actively engaged in usurpations of power, subverting the real law, the common law, the bills, plural, bills of rights, not just the Bill of Rights of 1789. There are many bills of rights, and in fact, every state has its own Bill of Rights. So bills of rights, and those merely declaratory of the common law. Our rights are actually the law. The law was laid down prior to instituting government. But this seems to be such a hard concept for most people to grasp, that we already have the law laid down, because that's what a declaration does, is it lays down the law. And that's why they're called a Declaration of Rights or Bills of Rights. They're declarations. That's the law. And government was instituted to secure that law. We don't make law through the legislature after we created government. That's not how that's done. And again, This is that concept that people just cannot seem to grasp. But at some point in time, this needs to be stopped. It needs to be shut down. This usurpation of power, waste of taxpayer dollars and times, pretending that you folks have some sort of authority to make law, and they don't. Natural rights and civil rights have absolutely nothing to do with the establishment, support, or management of government. Okay, American Jurisprudence, Volume 15, Civil Rights, Section 2. Read it. That is not within the scope and authority delegated to government. Receiving their just powers under the consent of the government, under the governed. You weren't given consent. You weren't given that just power. There is no power to alter God's law, the fundamental law of this nation called America. We already have the law of the nation. That's why it's called the common law. And this is the American common law, not the common law of England. While that was adopted first back in 1606 with the first Charter of Virginia, that is still not the American common law. We adopted certain parts of the English common law and basically told Great Britain, kick rocks back then, trying to separate from the Roman Catholic Church again. The first Charter of Virginia was 1606. All right, so no further ado, we're going to jump back into this wonderful writing by Joseph Story, Commentaries on the Constitution. I notice that this is the Federalist Papers project. So knowing this is that the Federalist Papers were published in the newspaper. And it was explaining to the people what the Constitution actually is going to mean, the verbiage, because this was during the time of creating the Constitution itself, during the Constitutional Convention, creating the Constitution. So they felt it necessary to publish this in the news, in the newspapers. And it has actually been ruled in the Supreme Courts, many of them, that the Federalist Papers is the true meaning behind the Constitution, and it is most certainly quotable as the true meaning behind the words in the Constitution of the United States of America, 1787. And, oh yeah, right there again. The constitutional history of the colonies and states before the adoption of the Constitution for the use of colleges and high schools. So this is actually supposed to be in school. It's what it's supposed to actually be taught. Now, I can't even actually remember where we left off. But I mean, this is the way I was doing it was just word by word, but kind of want to jump down to where it starts talking about the Constitution itself and breaking it down. And I actually may just go to the table of contents for that before I get too far. Out of whack. See, this here is where we're talking about here is it breaks it down. And one of those sections I've covered before, and I've used it. Where is it? It was like 5 something. This ought to be a good section to read at one point in time. Definition, evidence of treason. But there's a section here that talks about those titles of nobility. Where in the heck was that? Now we're hiding it, huh? Thought it was like 580 something right in here. That says the judiciary. Where in the heck? Oh, that's why. No, that's book 2. Well, what's in book 1? Oh. Yeah, see all these main colonies here, right? How they got started. History of the Revolution, origin of the Confederation, House of Lords Confederation. Right here would probably be a really good one. Who is the final judge or interpreter in constitutional controversies? Now, I've read this part here, the nature of the Constitution. Well, it is a compact. It's a social compact, which is kind of like a contract. Page away, there's 106. And I'll blow this up here in just a second. There we go. Oh, one more. Why are you gonna be such a pain? All right, so we're talking about nature of the Constitution and whether it's a compact. Having this sketched out a general history of the origin and adoption of the Constitution of the United States and the summary of the principal objections and difficulties which had to encounter, we are at length arrived at the point at which it may be proper to enter upon the consideration of the actual structure, organization, and powers which belong to it. Now, this is key. Knowing what powers were actually delegated. Before doing this, however, it seems necessary in the first place to bestow some attention upon several points which have attracted a good deal of discussion, and which are preliminary in their own nature. And in the next place, to consider what are the true rules of interpretation belonging to the instrument. So, in the first place, what is the true nature and import of the instrument? Remember, this is supposed to be an instrument of government, the piece of paper. Okay. It is a treaty, a convention, a league of friendship, a contract. Oh, is it? Pardon me. So this is question. Is it a treaty, a convention, a league, a contract, or a compact? Who are the parties to it? By whom was it made? By whom was it ratified? What are its obligations? By whom and in what manner may it be dissolved? Who are to determine its validity and construction? Who are to decide upon the supposed infractions and violations of it? These are questions often asked and often discussed, not merely for the purpose of theoretical speculation, but as matters of practical importance and of earnest and even of vehement debate. The answers given to them by statesmen and jurists are often contradictory and irreconcilable with each other, and the consequences deduced from the views taken of some of them go very deep into the foundations of the government itself and expose it, if not to utter destruction, at least to evils which threaten its existence and disturb the just operation of its powers. Imagine that there might be people out there that are so evil that they will twist it to mean something that it doesn't. Okay. In what light, then, is the Constitution of the United States to be regarded? It is a mere compact. Treaty? No, pardon me. Is it a mere compact, treaty, or confederation of the states composing the Union, or of the people thereof, whereby each of the several states and the people thereof have respectively bound themselves to each other? Or is it a form of government, which, having been ratified by a majority of the people in all the states, is obligatory upon them as the prescribed rule of conduct of the sovereign power to the extent of its provisions? Let us consider in the first place whether it is to be deemed a compact. By this, we do not mean an act of solemn assent by the people to it as a form of government, or which there is no room for doubt, but a contract imposing mutual obligations and contemplating the permanent subsistence of parties having an independent right to construe, control, and judge of its obligations. If in this latter sense it is to be deemed a compact, it must be either because it contains on its face stipulations to that effect, or because it is necessarily implied from the nature and objects of a frame of government. There is nowhere found upon the face of the Constitution any clause intimating it to be a compact, or in any wise providing for its interpretation as such. BS, Article 6, Clause 3. Everyone from the legislative, executive, and judicial shall be bound by oath or affirmation to support this Constitution, both state and federal. That's a compact between the states that created it and all other states who wish to join the Union. Oh, on the contrary, the preamble emphatically speaks of it as a solemn ordinance and establishment of government. The language is, we, the people of the United States, do ordain and establish this Constitution for the United States of America. The people do ordain and establish, not contract and stipulate with each other. Really. people of the United States, not the distinct people of a particular state with the people of the other states. The people ordain and establish a constitution, not a confederation. Wait a minute. The Confederation was already there. And if you're going to take it out of context, which is what he's doing here, the fact is it says in order to form a more perfect union. But let's see what else he has to say. Maybe he's just speculating here. This distinction between a constitution and a confederation is well known and understood. The latter, confederation, or at least a pure confederation, is a mere treaty or league between independent states and binds no longer than during the good pleasure of each. It rests forever in articles of compact, where each is or may be supreme judge of its own rights and duties. The former is a permanent form of government, where the powers once given are irrevocable and cannot be resumed or withdrawn at pleasure. Whether formed by a single people or by different societies of people in their political capacity, a constitution, though originating in consent, becomes, when ratified, obligatory as a fundamental ordinance or law. The constitution of a confederated republic, that is, of a national republic, formed of several states, is, or at least may be, not less an irrevocable form of government than the constitution of a state formed and ratified by an aggregate of the several counties of the state. Okay, so he's getting there. If it had been the design of the framers of the Constitution or the people who ratified it to consider it a mere confederation resting on treaty stipulations, it is difficult to conceive that the appropriate term should not have been found in it. The United States were no strangers to compacts of this nature. They had subsisted to a limited extent before the Revolution. The Articles of Confederation, though in some few respects what the heck did I miss there? Few respects national, were mainly of a pure federative character and were treated as stipulations between states for many purposes independent and sovereign. And yet, has been already seen, it was deemed a political heresy to maintain that under it, any state had a right to withdraw from it at pleasure and repeal its operation, and that a party to the compact had a right to revoke that compact. But that which would seem conclusive on the subject, and has been already stated, is the very language of the Constitution itself, declaring it to be a supreme fundamental law and to be of judicial obligation and recognition in the administration of justice. This Constitution, says the 6th article, and the laws of the United States which shall be made pursuant thereof. It must be in the Constitution itself to be made pursuant thereof. So subject matter jurisdiction has to be there in order to be in pursuant thereof. And all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of a state to the contrary notwithstanding. This seems to be a relatively hard concept for people in the states to comprehend, that even something in the Idaho Constitution that says one thing that comes in conflict with the supreme law of the land, the Constitution, is void for any effect, because that's what notwithstanding. It has no standing in law. So we're the Second Amendment of the Bill of Rights, which is Article the 2nd, says that the right of the people to keep and bear arms shall not be infringed. There is no delegation of subject matter jurisdiction over that right. It's a Bill of Rights. And it most certainly applies to the states because the states made it. And it's just a Bill of Rights, which is merely declaratory of the common law. So we don't need the 14th Amendment, which is a fraud, scheme, scam, and a fraud anyways. Anything after 1861 to begin with is all fraud. It's void for any effect because Congress didn't have that power to begin with. So, this is the major misconception about the Bill of Rights, 1789. Well, it doesn't apply to the states except by and through the 14th Amendment. Really? That's funny because all the states assembled in a constitutional convention created it. So how would it not be the law, the common law? And it's a Declaration of Rights. It's a Bill of Rights. And it is most definitely 1 through 8 declaratory, merely declaratory of the common law. So again, it's already the common law. This is why it says in the Declaration of Independence that this is supposed to be self-evident. Common sense law, the law that is common to all. And we made sure that we had this supreme law of the land, supreme due process of law. And that the judges, why is it that the judges in every state shall be bound thereby? Because the judicial branch is the one that's supposed to provide checks and balances of anything that gets created by the legislature or any actions taken by the executive. That's the thought, right? Except for actually, we're supposed to redress our grievances with the legislature, not the judicial. But this is the major misconception is we go to the judicial because see right there, the judges are supposed to do that. No, that's for declaratory judgments, a challenge to the constitutionality of creating something in the legislature to declare it either constitutional or not. That's it. That's a suit in law. Okay? So, if it is the supreme law, how can the people of any state, either by any form of its own constitution or laws or other proceedings, repeal or abrogate or suspend it? That's a very good question. The language of the Constitution were less explicit and irresistible. No other inference could be correctly deduced from a view of the nature and objects of the instrument. The design is to establish a form of government. This, of itself, imports legal obligation, permanence, and uncontrollability by any but the authorities authorized to alter or abolish it through a constitutional convention, Article 5. This is one of the things that I brought up here in Idaho to one of our Idaho representatives. You don't have the authority to alter the Idaho Constitution without a constitutional convention. See the supreme law of the land, Article 5. Well, the Idaho Constitution says, see Article 6, Clause 2. Anything in the Constitution or laws of a state to the contrary are notwithstanding. It's void for any effect. You cannot subvert the law of creation. It's the supreme law of the land for a reason. It's the supreme due process of law to bring things into being, to make amendments, to alter. You have to have an Article 5 convention. It takes an Article 5 convention to create a state, Article 4, Section 3, when the people of a territory want to form their own government, well, you've got to apply to Congress. And then the states that are there at the time send delegates to assemble in Congress, and they create what? The Organic Law. An organic act for the territory of Idaho was done in 1863 by Congress of the United States of America. That's pursuant to due process of law, the law of creation. How does it get created? How do new states join the Union? And if it's a union, it is in fact a confederacy, because a union is a league of friendship. A league of friendship is a confederacy, and that's why it's a Confederate republic, not a representative democracy, not a democracy. We're a Confederate republic, period. End of discussion. It's what it says in the preamble. In order to form a more perfect union, which is an indicator that we already had a perfect union, the Articles of Confederation. That's a fact of law. There is no giving rebuttal to that, because that's what it says as it is written. And those words have meaning. So, let's see. Designed to establish a form, thus of itself imports legal obligation, permanence, and uncontrollability by any, but the authorities authorized to alter or abolish it. The object was to secure the blessings of liberty to the people and to their posterity. The avowed intention was to supersede the old Confederation and substitute in its place a new form of government. That would be false, because why would it say in order to form a more perfect union if it wasn't already a perfect union to begin with? So right here, Mr. Story is misconstruing what it says as it is written to begin with. You're leaving out certain parts, aren't you? We have seen that the inefficiency of the old Confederation forced the states to surrender the League, then existing, and to establish a national constitution. But see, if we already have the Articles of Confederation and that was signed off on, creating that League of Friendship, the Union, which says that it cannot be altered and it is forever perpetual union, and it requires all of the states to alter it. You have to have all of them. That means Article 7 of the Constitution, where it says 9 states shall be sufficient, is a fraud. And I've made this argument before, and that is, one, if we're going to say that the Articles of Confederation are void, it's just the old stuff. We don't, the Constitution voided that, really, because there's a clause in there that says it requires all of the states to do this. And 9, how many states did we have back then? 13. So no, 9 shall not be sufficient to alter the Articles of Confederation, because the clause dictates you have to have all 13. So either the Articles of Confederation are in full force and effect, and the Constitution overlays it, just like it says in Federalist 45, or the Constitution is void for any effect for fraud, because it violated one of the clauses, terms and conditions of the Articles of Confederation. You can't have it both ways. And that gets defeated through contract law. Period. There's a clause in the contract, and there shall be no law impairing the obligations of a contract. And it's an Articles of Confederation. It is most definitely a compact, social compact. So The convention also, which framed the Constitution, declared this in the letter accompanying it. It is obviously impractical in the federal government of these states, says the letter, to secure all rights of independent sovereignty to each and yet provide for the interest and safety of all. Individuals entering into society must give up a share of liberty to preserve the rest. In all our deliberations on the subject, we kept steadily in our view that which appeared to us the greatest interest of every true American, the consolidation of our union. Okay, we keep talking about it. It's a union in which is involved in our prosperity, felicity, safety, perhaps our national existence. Could this be attained consistently with the notion of an existing treaty or confederacy, which each at its pleasure was at liberty to dissolve? No, that's not true, because the clause in there says it takes all of them. It's a forever perpetual union, and it's invoidable. Did you read it? Because it came before the Constitution. It is also historically known that one of the objections taken by the opponents of the Constitution was that it is not a confederation of the states, but a government of individuals. It was, nevertheless, in the solemn instruments of ratification by the people of the several states, assented to as a constitution. And although many declarations of rights, what's that say? And although many declarations of rights, many propositions of amendments, and many protestations of reserved powers are to be found accompanying the ratifications of the various conventions, sufficiently evince of the extreme caution and jealousy of those bodies and of the people at large, it is remarkable that there is nowhere to be found the slightest allusion to the instrument as a confederation or compact of states in their sovereign capacity, and no reservation of any right on the part of any state to dissolve its connection, or to abrogate its assent, or to suspend the operations of the Constitution as to itself. Well, let's read here. So that there is very strong negative testimony against the notion of its being a compact or confederation, founded upon the known history of the times and the acts of ratification, as well as upon the antecedent articles. What is that? Antecedent articles of confederation. The latter purported on their face to be a mere confederacy. The language of the third article was that the said states hereby severally enter into a firm league of friendship with each other for their common defense, and binding themselves to assist each other. Well, there you go. And the ratification was by delegates of the state legislatures, who solemnly plighted and engaged the faith of their respective constituents that they should abide by the determination of the United States in Congress assembled on all questions which by the said confederation are submitted to them, and that the articles therefore should be invoidably observed by the states they respectively represented. There it is. Inviolably. Basically, it's unvoidable. You cannot make it void. You have to observe it, every last bit of it. So let's go take a look at that. I'm going to have to do a stop and reshare so I can bring that up. I will just read to you from the Articles of Confederation itself. we'll go from there. Let me very top. I know this is a tough one, right? The style of this confederacy shall be the United States of America. Are we still not the United States of America? United being a verb, action. We are united, a union, right? Each state retains its sovereignty, freedom, and independence in every power, jurisdiction, and right, which is not by this confederation expressly delegated to the United States in Congress assembled. It sure sounds like we still had federalism here going on, didn't we? Yes, we did. The said states hereby severally enter into a firm league of friendship with each other for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other against all force offered to or attacks made upon them or any of them on account of religion, sovereignty, trade, or any other pretense whatever. The better to secure the perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of these states, paupers, vagabonds, and fugitives from justice accepted. Wait a minute. Who, what, where? Whoa. What's those words? What do they mean? Who are the free inhabitants? Who are paupers? Who are vagabonds? And who are fugitives from justice accepted? Shall be entitled to all privileges and immunities of free citizens in the several states. Wait, so now we got like free inhabitants and we got free citizens. Clearly there's a clear distinction, and those words have meanings, don't they? And the people of each state shall, now we're talking people. So now we got free inhabitants, we got free citizens, and we got people. We got paupers, we got all sorts of types of people here. Oh, but they don't want us to know about those terms, those words, that status. And the people of each state shall free ingress and regress to and from any other state, and shall enjoy therein all the privileges of trade and commerce. See, that's privileges. It's a privilege to do business in our communities. Not a right. It's a privilege. Subject to the same duties, impositions, and restrictions as the inhabitants thereof respectively, provided that such restrictions shall not extend so far as to prevent the removal of property imported in any state to any other state, of which the owner is an inhabitant, provided also that no imposition, duties, or restrictions shall be laid by any state on the property of the United States or either of them. Any person guilty of or charged with treason, felony, or other high misdemeanor in any state shall flee from justice and be found in any other state shall be deemed upon demand of the governor or executive power of the state from which he fled, be delivered up and removed to the state having jurisdiction extradition. Full faith and credit shall be given in each of these states to the records, acts, and judicial proceedings of the courts and magistrates of every other state. I mean, doesn't this sound like what the Constitution already says? Full faith and credit clause, Article 4, Section 1. Imagine that. But I'm going to go down here. Oh, wait. Here's one of those where it talks about how the right to freedom of speech works. Freedom of speech and debate in Congress shall not be impeached or questioned in any court or place out of Congress. And the members of Congress shall be protected in their persons from arrest or imprisonments during the time of their going to and from and attendance of Congress, except for treason, felony, or breach of the peace. It's exactly what it says in the Idaho Constitution. It's what it says in the Constitution of the United States of America. Duh. Let's see. Let's go down here. The United States, this is section Article 9, shall be assembled, shall have the sole and exclusive right and power of determining on peace and war, except in cases mentioned in the 6th article, of sending and receiving ambassadors and in treaties and alliance, providing. Let's see. Where's the one I'm looking for where it talks about 2/3? Okay, so here's where they tried to. This is the trickery, the scheme, scam, and the fraud right here. Article 10, the committee of the states, or any 9 of them, shall be authorized to execute in the recess of Congress. So we're talking about in committee. In the recess of Congress, such of the powers of Congress as the United States and Congress assemble by the consent of the 9 states shall from time to time think expedient to vest them with, provided that no power be delegated to the said committee, for the exercise of which by the Articles of Confederation, the voice of 9 states in Congress of the United States is assembled be requisite. So this is where they polled, well, 9 states assembled for this in a committee, but like it says, must be vested with that power, and no power be delegated to the said committee, for the exercise of which the Articles of Confederation. Watch this. We'll go down to the 16th article. Or wait, no, it's 13th. Pardon me. Where is it? 14th. 13th. Every state shall abide by the determination of the United States and Congress assembled. A committee is not Congress assembled. On all questions by which the Confederation are submitted to them, and the Articles of Confederation shall be inviolably observed by every state, and the Union shall be perpetual. Nor shall any alteration at any time hereafter be made in any of them. Pay attention. Unless such alteration be agreed in a Congress of the United States and be afterwards confirmed by the legislatures of every state. 9 states shall not be sufficient to overthrow the Articles of Confederation and create the Constitution of the United States of America, because 9 states of a committee is not Congress assembled. Sorry, this is the clause I was referring to. And what they've done is they've gone off of Article 10 and said, oh, well, yeah, we can do it. We can do it. It says it right there. The committee of the states, or any 9 of them, shall be authorized to execute in the recess of Congress. Whoops. Such of the powers of Congress as the United States and Congress assembled by the consent of the 9 states shall from time to time think expedient to vest them with, provided that no power be delegated to the said committee, for the exercise of which by the Articles of Confederation the voice of 9 states in Congress of the United States assembled be requisite. Now this is a great one. Canada acceding to this confederation, so this is where Canada is part of the nation called America, and adjoining in the measures of the United States, shall be admitted into and entitled to all the advantages of this union, but no other colony shall be admitted into the same unless such admission be agreed to by 9 states. Okay, now there's a clause that says it only takes 9 states for people to join. But see, Article 13, they made it very clear that it has to be all of the states. 9 states shall not be sufficient. Because the Articles of Confederation shall be inviolably observed by every state, and the union shall be perpetual, nor shall any alteration at any time hereafter be made in any of them, unless alteration be agreed to in a Congress of the United States and be afterwards confirmed by the legislatures of every state. You had to assemble all 13 states in Congress. Not 9, 13. So when we go and look at, well, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. That's a clear indication that the Bill of Rights is part of the Constitution, because the enumeration in the Constitution, if we're talking about the Bill of Rights as articles in addition to, it's not the Ninth Amendment, it's Article the Ninth. Because that's what it says in the Bill of Rights, articles in addition to an amendment to the Constitution. So if it's an amendment to the Constitution of the United States of America, it is most certainly part of the Constitution. And it most certainly applies to the states, because it was created in 1789. And most of the other states were created after that. So it came before all these other states that joined the Union. But I'm going to show you the conflict. Article 7, the ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states so ratifying the same. We better read that again. You just violated that clause in the Articles of Confederation. You just subverted the law of creation and the powers delegated. So, like I said, either the Articles of Confederation are in full force and effect right here, right now, today, or the Constitution of the United States of America is void for fraud. That's your choice. Pick one. In either pick, the Articles of Confederation win, based on what it says. It's the terms and conditions of the contract. And it's very clear that these people have forgotten to read the preamble. We, the people of the United States, in order to form a more perfect union. Now, let's read this in context. We, the people, establish justice. Not government. We, the people, do. We, the people, ensure domestic tranquility. Not the government. We, the people, provide for the common defense, which is why the people have the right to keep and bear arms, and that right shall not be infringed. We, the people, promote the general welfare. We, the people, secure the blessings of liberty to ourselves and our posterity. We, the people, do ordain and establish this Constitution for the United States of America. This is a power retained by the people, right in the preamble. These are powers retained by the people. They only have the power that is delegated. Here, scope of legislative power. These are the powers delegated. Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. That's mandatory. Shall be uniform. Do we have any taxes that are not uniform within the United States? It's fraud, void for any effect, because that power doesn't exist. Here's Federalist 45, what we're talking about here. To regulate commerce with foreign nations and among the several states and with the Indian tribes. So that's foreign commerce in the states, foreign commerce in the Indian tribes. If we're going to read that as it is written. Where are they at on coining money? Regulate the value thereof and of foreign coin and fix the standard of weights and measures. To coin money. Coin, not print on paper. Because you got to have those weights and measures that have a, fixed weight. That's why we say ounces of gold. An ounce of gold is $1,783 or whatever it is. That's fixing the weights and measure. To provide for the punishment of counterfeiting the securities and current coin of the United States. Well, I guess we need to exercise that power and start punishing the Fed, because they're printing doll hairs, and that's a counterfeit. It's not coinage. Oh boy. Now, this is what we're also talking about right here. What does this say? It says to constitute tribunals inferior to the Supreme Court. That's because Article 3, Section 2 is admiralty jurisdiction. And they are military tribunals. These are courts of the United States. And our common law courts are not courts of the United States. Like it says in the 7th Amendment, or Article the 7th, no fact tried by a jury in the common law courts, suits at the common law, shall be heard in any courts of the United States except pursuant to the rules of the common law. Whoops. How many people picked up on that? The Congress has the power to declare war, to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. So when they declare war and to raise and support the armies in defense of the nation called America, it can't be done for longer than 2 years. Part of the terms and conditions of the contract of employment here. To provide for calling forth the militia to execute the laws of the Union. Well, that's a confederacy. A union is a confederacy. Suppress insurrections and repel invasions. Domestic violence, Article 4, Section 4. Internal insurrection. All right, so back to which by the said confederation are submitted to them, and that the articles therefore should be inviolably observed by the states they respectively represented. That's right. It is not unworthy of an observation that in the debates of the various conventions called to examine and ratify the Constitution, this subject did not pass without discussion. The opponents on many occasions pressed the objection that it was a consolidated government and contrasted it with the Confederation. See, none of its advocates pretended to deny that its design was to establish a national government as contradistinguished from a mere league or treaty. However, they might oppose the suggestion that it was a consolidation of the states. The cardinal conclusion for which this doctrine of a compact has been, with so much ingenuity and ability, forced into the language of the Constitution, for the latter nowhere alludes to it, it is avowedly to establish that in construing the Constitution, there is no common umpire, but that each state, nay, each department of the government of each state, is the supreme judge for itself of the powers and rights and duties arising under that instrument. But if it were admitted that the Constitution is a compact, the conclusion that there is no common arbiter would neither be a necessary nor a natural conclusion from that fact standing alone. To decide upon the point, it would still behoove us to examine the very terms of the Constitution, terms and conditions of a contract, and the delegations of powers under it. It would be perfectly competent even for confederated states to agree upon and delegate authority to construe the compact to a common arbiter. The people of the United States had an unquestionable right to confide this power to the government of the United States or to any department thereof, if they chose so to do. The question is whether they have done it. If they have, it becomes obligatory and binding upon all the states. It is not then by artificial reasoning founded upon theory, but upon a careful survey of the language of the Constitution itself, that we are to interpret its powers and its obligations. We are to treat it as it purports on its face to be, as a constitution of government, and we are to reject all other appellations and definitions of it, such as that it is a compact, especially as they may mislead us into false constructions and glosses and can have no tendency to instruct us in its real objects. So, we all think of that. So, this is why I like to go back to the Federalist Papers. Because it really does lay this out, right? Let's see. And I just really love 45 because it really just hammers this home. The alleged danger from the powers of the Union to the state governments considered for the independent formal, okay, to the people of the state of New York, having shown that no one of the powers transferred to the federal government is unnecessary or improper. So all we're doing is transferring powers. We're basically, the argument was that, oh, well, the Articles of Confederation failed and blah, 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 blah. No. There's a couple things that may have failed there, and it's expressed here in the Federalist Papers, and it was discussed how to defend the states. But see, look at what they're saying there. The next question to be considered is whether the whole mass of them will be dangerous to the portion of authority left in the several states. The adversaries to the plan of the convention, instead of considering in the first place what degree of power was absolutely necessary for the purposes of the federal government, have exhausted themselves into a secondary inquiry into the possible consequences of the proposed degree of power to the governments of the particular states. But if the union, as has been shown, be essential to the security of the people of America against foreign danger, if it be essential to their security against contentions and wars among the different states, if it be essential to guard them against those violent and oppressive factions which embitter the blessings of liberty, and against those military establishments which must gradually poison its very foundation, if, in a word, the Union be essential to the happiness of the people of America, is it not preposterous to urge as an objection to a government without which the objects of the Union cannot be attained, that such a government may derogate from the importance of the governments of individual states? Was then the American Revolution effected? Was the American Confederacy formed? Was the precious blood of thousands spilt and the hard-earned substance of millions lavished? Not that the people of America should enjoy peace, liberty, and safety, but that the government of the individual states, that particular municipal establishments, might enjoy a certain extent of power and be arrayed with certain dignities and attributes of sovereignty? We have heard the impious doctrine in the old world that the people were made for kings, not kings for the people. Ooh. Is the same doctrine to be revived in the new in another shape, that the solid happiness of the people is to be sacrificed to the views of political institutions on a different form? And they're all saying, no way, Jose. We're done with being ruled by rulers. But we get down to the bottom of the root of it here. We talk about right here. The powers reserved to the several states will extend to all the objects which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. The operations of the federal government will be most extensive and important in times of war and danger. What did I just read there in Article 1, Section 8? War and danger, internal insurrection, to declare war and to protect us from internal insurrections. Those of the state governments in times of peace, pay attention here, and security. Wait a minute. So the operations of the federal government will be most extensive and important in times of war and danger. Those of state governments in times of peace and security. Because a militia being necessary for the security of a free state, not a police force. Oh boy, do I have something good for that. So, as the former periods will probably bear a small proportion to the latter, the state governments will here enjoy another advantage over the federal government. The more adequate, indeed, the federal powers may be rendered to the national defense, the less frequent will be those scenes of danger which might favor their ascendancy over the governments of particular states. So, in other words, we'll provide for the federal military militia. We'll provide for that. The states will. So we actually have people from all of the states trained to arms as federal government military. So that way, people from all of the states are providing defense of the nation. Federally, not state. So, if the new Constitution be examined with accuracy and candor, it will be found that the change which proposes consists much less in addition to new powers to the Union than in the invigoration of its original powers. The regulation of commerce, it is true, is a new power. Whoa. From the Federalist Papers. What are we talking about here? Article 1, Section 8, Clause 3. But that seems to be an addition which few oppose. Right? So why not put the power of regulation into the hands of all of the states assembled in Congress? Because that's what Congress is delegates sent from the states assembled in Congress to make policy to regulate commerce. That would be the legislative branch, not the executive. Why do we have today where we think for some reason that the executive branch makes these rules to regulate? Negative. So, but that seems to be an addition which few oppose and from which no apprehensions are entertained. The powers relating to war and peace, armies and fleets, treaties and finance, with the other more considerable powers, are all vested in the existing Congress by the Articles of Confederation. The proposed change does not enlarge these powers. It only substitutes a more effectual mode of administering them. So if that's the case, according to the Federalist Papers here, the Articles of Confederation are most definitely still in full force and effect. Whatever it says in the Articles of Confederation is supposed to be perpetual. It's the law as it is written. So if we didn't change anything, that's why it's a more perfect union. There isn't anything that we really changed. We only delegated powers to Congress assembled, which again is nothing but delegates sent from the states assembled in a Congress. See, this is where we get confused and talk about, well, we got two governments. We got the federal government and we got the state government. Well, it's federal powers, not necessarily a federal government. We only have but one Republican form of government. One legislative branch, one executive branch, and one judicial branch. And this is where we have to comprehend that the President of the United States of America is the Commander-in-Chief of the Army and the Navy, and that the governors are under the President in the states. But Congress has the power to declare war. So all of the states have to send their delegates in Congress assembled for the purpose of whether we're going to declare war or not. That's how our Republican form of government works. But see, we've gotten to the point where we seem to think that, well, federal government's federal government and state government's state government. Wrong. It's but one form of government. As it is written right here, what it says, the proposed change does not enlarge these powers. It only substitutes a more effectual mode of administering them. So that's all that we're really changing. The fundamental principles of the Articles of Confederation are still embedded into the Constitution. I just read some of that from you. From the Articles of Confederation, they just reiterated it in the Constitution. So the change relating to taxation may be regarded as the most important, and yet the present Congress have as complete authority to require of the states indefinite supplies of money for the common defense and general welfare, as the future Congress will have to require them of individual citizens, and the latter will be no more bound than the states themselves have been to pay the quotas respectively taxed on them. Had the states complied punctually with the Articles of Confederation, or could their compliance have been enforced by as peaceable means as may be used with success toward single persons, our past experience is very far from countenancing an opinion that the state governments would have lost their constitutional powers and have gradually undergone an entire consolidation. To maintain that such an event would have ensued would be to say at once that the existence of the state governments is incompatible with any system whatever that accomplishes the essential purposes of the Union. Bingo. So, as we can see, there wasn't really supposed to be that much of a change, and we just delegated some powers to the Congress that was already there. Remember? We already had the Congress. It's part of the Articles of Confederation. There isn't much that really changed. It's just certain powers were delegated to that Congress that was already created by the Articles of Confederation. But you can't make the Articles of Confederation void unless you have the consent of all the states. And 9 states is only a committee. You have to assemble all 13 states in a convention. Because a committee is not a convention. According to the 10th article of the Articles of Confederation, we've been duped, we've been lied to, it's been subverted. Just saying, pointing it out. I didn't write it. It's what it says as it is written. So who's the final judge or interpreter in constitutional controversies? Now let's find out as he actually talks about the common law here or not, which would be jury nullification. Technically speaking, this is the power that belongs to the people, the right to alter, reform, or abolish anything at any time we deem it necessary, would have to include the common law jury. Because all political power is inherent in the people. The right to alter, reform, or abolish anything at any time we deem it necessary would be during that time of sitting on a jury. They don't like us to know this, that our common law juries have the power to judge the law, and the facts. Oh, no. No, the juries are only supposed to judge the facts and the court's supposed to judge the law. Liar. But let's find out. Let's see. The consideration of the question whether the Constitution has made provision for any common arbiter to construe its powers and obligations would properly find a place in the analysis of different clauses of that instrument. But as it is immediately connected with the subject before us, it seems expedient in the place to give it a deliberate attention. Well, let's see what your deliberate attention is. In order to clear the question of all minor points, which might embarrass us in the discussion, it is necessary to suggest a few preliminary remarks. The Constitution, contemplating the grant of limited powers and distributing them among various functionaries, and the state governments and their functionaries, being also clothed with limited powers, subordinate to those granted to the general government, whenever any question arises as to the exercise of any power by any of these functionaries under the state or federal government, it is of necessity that such functionaries must, in the first instance, decide upon the constitutionality of the exercise of such power. It may arise in the course of the discharge of the functions of any one or of all of the great departments of government the executive, the legislative, and the judicial. Well, wait a minute. Where's the federal? Where's the federal government? No. We only have 3 branches of government. Period. End of discussion. The officers of each of these departments are equally bound by their oaths of office to support the Constitution of the United States and are therefore conscientiously bound to abstain from all acts which are inconsistent with it. That's Article 6, Clause 3. Everyone from the legislative, executive, and judicial branch, both state and federal, shall be bound by oath or affirmation to support this Constitution. It's just common sense. Whenever, therefore, they are required to act in a case, oh boy, this might be good, not hitherto settled by any proper authority, these functionaries must, in the first instance, decide, each for himself, whether consistently with the Constitution the act can be done. Uh-oh. They're supposed to look at the Constitution and go, well, can this act be done? Does the Constitution allow this or forbid it? Because the Constitution is supposed to dictate that, right? So, if, for instance, the president is required to do any act, he is not only authorized, but required to decide for himself whether consistently with his constitutional duties he can do the act. So this actually goes back to some of the things that was said there. Attorney General Barr and stuff, with the impeachment and stuff, that the first one, that the president was going to start exercising powers properly belonging to the executive branch pursuant to the Constitution. We may start seeing some of them. I think it's already been happening, but I think it's going to come out. We're going to start seeing a little bit more and a little bit more. We'll see here soon. I'm already aware of, the U.S. Marshals have been going around making arrests of child pedophilia stuff, and people have been getting arrested. I've been sharing it. I've been showing it. So we can't deny the fact that people are getting arrested, that there are people going to prison, that there is something being done. To deny that, I mean, it's just pure idiocracy. So, if a proposition be before Congress, every member of the legislative body is bound to examine. Pay attention to that. If a proposition be before Congress, every member of the legislative body is bound to examine and decide for himself whether the bill or resolution is within the constitutional reach of the legislative powers confided to Congress. So if a petition is filed, they're bound to do it. They're bound to examine it. Because our rights dictate that. That's a required duty to discharge, to perform. Okay, just saying. And in many cases, the decision of the executive and legislative departments thus made become final and conclusive. What does that say? And in many cases, the decisions of the executive and legislative departments thus made become final and conclusive, being from their very nature and character incapable of revision. Thus, in measures exclusively of political, legislative, or executive character, it is plain that the supreme authority as to these questions belongs to the legislative and executive departments. They cannot be re-examined elsewhere, with the exception of providing oversight. Is this constitutional or not? That's declaratory judgment. To declare this constitutional or unconstitutional. The Constitution says this. This is what the legislature did. This is what the executive did. Is that in conflict with the Constitution? Yes or no? That's a declaratory judgment. So, the constitutionality challenge to this statute. So, let's see. Thus, Congress having the power to declare war, to levy taxes, to appropriate money. Now, this particular part I will agree with, that if the Constitution says Congress has the power to declare war, there is no need to review when Congress decides to declare war, because that is a proper function of Congress. It is in the clear and plain language of the Constitution that Congress has the power to declare war. Anyone else who tries to exercise that power would be unconstitutional, because that power is specifically delegated to Congress and Congress alone. So in that sense, that doesn't need to be reviewed by anyone or re-examined anywhere else. So, to levy taxes, to appropriate money, to regulate intercourse and commerce with foreign nations. Oh, thank you for putting that in there just exactly how I was saying it. It's to regulate commerce with foreign nations and the states, between foreign nations and the Indian tribes. That's the limitation per the Constitution as it is written. We read it correctly, but it's been construed as, oh, well, we can regulate everything we deem as commerce. I've read some case law stuff on this, and that's what they say. Well, everything's frickin' commerce, and we get to regulate it because that's the Commerce Clause. Well, why is Joseph Story saying it the way I'm saying it, the way I read it, right from the Constitution itself, to regulate commerce between foreign nations and the states and foreign nations and the Indian tribes? And it's backed up right here. Congress having the power to declare war, to levy taxes, to appropriate money, to regulate intercourse and commerce with foreign nations. Their mode of executing these powers can never become the subject of re-examination in any other tribunal. So the power to make treaties being confided to the president and Senate. Now, see, it's also being made very clear here, too. It isn't just the legislature, it's also the executive. So if the president or the governor, they exercise powers that properly belong to them according to the Constitution itself, it can't be questioned. And this is part of what's been challenged here, is the fact that, Trump was starting to exercise powers and they kept trying to go to the judicial branch and challenging it. You can't do that. You can't go to the judicial branch to do that. It's in the clear and plain language of the Constitution that the president has those powers. So, thus, Congress having the power to declare self-limited powers can never become the subject of re-examination in any other tribunal. So the power to make treaties being confided to the president and Senate. What does that say there? So the power to make treaties being confided to the president and Senate. When a treaty is properly ratified, it becomes the law of the land, and no other tribunal can gainsay its stipulations, so long as it's in line with the Constitution, right? All treaties made pursuant to the Constitution. So the power and subject matter jurisdiction, we can't make a treaty that says, oh, well, the people no longer have these rights. That's because that's the common law and that's off limits to government. I don't care who they are. They're all public servants, and servants do not get to dictate to the people what the law is. The people dictate to the public servants what the law is, and government was instituted to secure those blessings of liberty. We secured it, so it's off limits, fundamentally and principally. So let's not forget that particular part. Okay. Properly ratified, so it has to go to the Senate. Senate has to do it. Then guess what? It has to go to the states, and it has to be ratified by all, well, would be what, 3/4 of the states. Yet cases may readily be imagined in which a tax may be laid or a treaty made upon motives and grounds wholly beside the intention of the Constitution. The remedy, however, in such cases solely by an appeal to the people at the elections. Aha. Or by the salutary power of amendment provided by the Constitution itself. So Article 5 Convention. So either Article 5 Convention or by the people. It's required. I mean, that's just the way it's our form of government is supposed to work. And like it says, solely by an appeal to the people at the elections. Because it's supposed to be submitted at the next election for ratification by the people of the states. That is the power that belongs to the people. So even if the president and the Senate go ahead and say, okay, we're going to do this treaty, it has to be put to a vote of the people at the next election before it becomes effective. It has to be ratified by the people. They probably don't want us to know about that. But where the question is of a different nature and capable of judicial inquiry and decision, there it admits of a very different consideration. Decision then made whether in favor or against the constitutionality of the act by the state or by the national authority, by the legislature or the executive being capable in its own nature of being brought to the test of the Constitution is subject to judicial revision. Like I said, it's a constitutionality challenge to the creation of something. Do they or do they not have the authority to create that or to execute that? That's it. That's what the judicial branch is for. To challenge the constitutionality of an enactment of the legislature or a conduct of the executive. Is it constitutional or not? It's a yes or no answer to the question. Here's the Constitution. Here's what they did. Uphold the Constitution. Does it come in conflict with the clear and plain language of the Constitution or not? It's not rocket science, folks. This is due process of law, providing oversight of the other branches of government. Same thing with the legislature, gets to provide oversight of the executive and the judicial. If the judicial steps outside its scope and authority pursuant to the Constitution, we go to the legislature for that. Redress of grievances. Well, wait a minute. Has the judicial branch exceeded its authority from the Constitution? That goes to the legislature. And if the legislature can't be convened, that would be the executive, wouldn't it? But so does the executive. The executive branch has the power to provide oversight of the judicial. In fact, they're supposed to be right there in the middle of the judicial processes, standing there as a bailiff. That's what the bailiff is there for, is to ensure that nothing unlawful happens, either from the judge or from any of the parties in the courtroom, and has the power to make that arrest on the spot. Kind of like the sergeant at arms in the legislature. Same principle. The sergeant at arms has the power to make arrests right there in the legislature. And they're not free, members of the legislature or Congress, during session, during assembled, are not free from arrest. They are free from arrest with the exceptions of treason, felonies, high crimes, and breaches of the peace. So they're not above the law at any time. And if we point that out while we're down there at the Capitol, the sergeant at arms is supposed to make the arrest. And we're supposed to be able to instruct the sergeant at arms to do that because, like I've already covered last Friday, we all have the right to make an arrest for a felony happening directly in front of us, for a breach of the peace. We all have that power. We can't delegate a power we do not possess ourselves first. So it's brought to the test of the Constitution, is subject to judicial revision. It is in such cases as we conceive that there is a final and common arbiter provided by the Constitution itself, to whose decisions all others are subordinate, and that arbiter is the supreme judicial authority of the courts of the Union. So anytime we've got a constitutionality challenge, it is supposed to go to the judicial, and that is enactments of the legislature and any rulemaking or regulation making of the executive. That is subject to review of the judicial. Not everything. Because why does it say we would take our redress of grievances to the legislature if we're going to sit here and say this all is the judicial authority? So my question is what exactly is it that they should be doing if they're going to go to the judicial about some election stuff, which I've already shown from parliamentary practice? Election petitions are supposed to be filed in the legislature, not the judicial. But if they were to challenge something, it would be challenging whether or not the executive branch actually created something, or did the judicial branch create something or allow something that's contrary to what the legislature already created and declare it unconstitutional. But that's to the extent of it. That's it. Was it constitutional or not? So, Sidney Powell and everybody out there that's pushing this stuff, why aren't you making the proper arguments to the judicial branch? Constitutionality challenge. That's it. Is this constitutional or not? That's it. Keep it simple, stupid. Let us examine the grounds on which this doctrine is maintained. The Constitution declares, Article 6, that this Constitution and laws of the United States, which shall be made in pursuance thereof, and all treaties shall be the supreme law of the land. It also declares, Article 3, that the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made, and which shall be made under their authority. It further declares, Article 3, that the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as Congress may from time to time ordain and establish, which are military tribunals. Because that's what it says in Article 1, Section 8. that they have the power to make tribunals inferior to the Supreme Court. So this is where the mix-up is that they seem to think that they have the power to make whatever court they choose. The Supreme Court is under admiralty jurisdiction, delegated in Article 3. Where does it say common law? It doesn't. Because the common law courts are our courts. They're not courts of the United States, and they're not supposed to be under the Supreme Court, unless we're going to talk about usurpations, subversion of law, internal insurrection under our common law courts. Sure. That's a suit in law, right? And that's why any fact tried by a jury shall not be re-examined in any courts of the United States except for pursuant to the rules of the common law. So what actually would they be re-examining on appeal? What would be the conduct of the actors that conducted the trial under common law? That's about it. Was this lawfully done or not? Shall be vested in one Supreme Court, such inferior courts and grounds made from time to time on Dana steps. Here then we have expressed indeterminate provisions upon the very subject. Nothing is imperfect and nothing is left to implication. The Constitution is the supreme law of the land. The judicial power extends to all cases arising in law and equity under it. And the courts of the United States are, and in the last resort, the Supreme Court of the United States is to be vested with this judicial power. No man can doubt or deny that the power to construe the Constitution is a judicial power. Not construe. They're supposed to uphold. We don't construe the Constitution. We put things to a test. Does it come in conflict with the Constitution itself? That's not saying that you have the power to construe the Constitution. In fact, you're all supposed to be bound to support it as it is written. You don't get to interpret the Constitution. You're supposed to interpret whether or not something comes in conflict with the Constitution, not the Constitution itself. The Constitution itself is not subject to the opinion of any branch of government. Hopefully he says that in here. The power to construe a treaty is clearly so. Okay, yeah. See, anything that's made under the Constitution, not the Constitution itself. So, okay. When the case arises in judgment in a controversy between individuals, the like principle must apply where the meaning of the Constitution arises in a judicial controversy, for it is an appropriate function of the judiciary to construe laws. If, then, a case under the Constitution does arise, if it is capable of judicial examination and decision, we see that the very tribunal is appointed to make the decision. The only point left open for controversy is whether such decision, when made, is conclusive and binding upon the states and the people of the states. The reasons why it should be so deemed will now be submitted. Oh boy, okay, let's see what we got here. In the first place, the judicial power of the United States rightfully extending to all cases, to all such cases, its judgment becomes ipso facto, conclusive between the parties before it. Pay attention. Between the parties before it. In respect to the points decided, unless some mode be pointed out by the Constitution in which that judgment may be revised. No such mode is pointed out. Congress is vested with ample authority to provide for the exercise by the Supreme Court of appellate jurisdiction from the decisions of all inferior tribunals, whether state or national. Oh, wait. So right here, he just says state tribunals. They're all military tribunals. Our common law courts are not courts of the United States. In cases within the purview of the judicial power of the United States, but no mode is provided by which any superior tribunal can re-examine what the Supreme Court has itself decided. Ours is emphatically a government of laws and not of men. And judicial decisions of the highest tribunal by the known course of the common law are considered as establishing the true constructions of the laws which are brought into controversy before it. Whoops. And judicial decisions of the highest tribunal by the known course of the common law. Why is he mentioning the common law there? Darn. Kind of shoots him in the foot there, don't it? As establishing the true construction of the laws, which are brought into controversy before it. The case is not alone. Now remember, talking about the case. The case, what? Wait a minute, did we miss that? Considered, okay. Considered as decided and settled is not, right? The case is not alone considered as decided and settled, but the principles of the decision are held as precedents and authority to bind future cases of the same nature. In other words, don't come back here and ask me the same question again. It's already been answered. This is the constant practice under our whole system of jurisprudence. So why do we keep, how many times can we go to the judicial branch and say, is this constitutional or not? And have the Supreme Court of the United States or Supreme Court of the state give its opinion? Come on, we've been going for 200 and some years now. How many times can we ask the same freaking question over and over and over and over and over again? That's insanity. Asking the same question over and over again and expecting different results. Well, that's exactly what they're doing ever since 1871 and the creation of the American Bar Association in 1878. They've infiltrated our government and keep going to the judicial branch and creating these opinions and rulings to subvert our rights and the law, the actual common law. Because they've reverted us back to a monarchy that says, oh, well, in a monarchy, this is how we make common law. Judicial decisions. Yeah, in a monarchy, but we're not a monarchy. In our republic, the judicial branch doesn't have the power to make law. We go back to the Seventh Amendment or Article the 7th, suits at the common law. So you're saying this is suits at stare decisis? Suits at case law? What does it mean when it says suits at the common law exceeding the value of $20, the right to a trial by a jury shall be preserved, and no fact tried by a jury shall be heard in any court of the United States except for pursuant to the rules of the common law? Whoops. I've defeated every single bar member that has made the comment that what the common law is case law. With that question right there. Explain the 7th Amendment or Article the 7th of the Bill of Rights. If you're saying that the common law is case law, then suits at the common law is suits at case law. The hell are you talking about? Well, why does American Jurisprudence, Volume 16, Constitutional Law, Section 100, specifically say that bills of rights are merely declaratory of the common law? Goes hand in hand with the 7th Amendment, doesn't it? And like it says there, only applies to the parties to the case. That's a Republican form of government. We didn't give them power. Right? Yeah, it's just the way it is. They just don't have that power, right? Oh man. Oh, let's see. I'm looking at some comments here. Yeah. Yeah, I know. It's just, we're just so far out away from reading what the Constitution actually says. But let's continue reading here because it looks like there might be something else here. The principal decision in our held precedence and authority to bind future cases of the same nature. This is the constant practice under our whole system of jurisprudence. Our ancestors brought it with them when they first emigrated to this country, and it is and always has been considered as the great security of our rights, our liberties, and our property. It is on this account that our laws is justly deemed certain and founded in permanent principles and not dependent on the caprice or will of particular judges. Bingo. A more alarming doctrine could not be promulgated by any American court than that it was a liberty to disregard all former rules and decisions and to decide for itself without reference to the settled course of antecedent principles. This known course of proceeding, this settled habit of thinking, this conclusive effect of judicial adjudications was in the full view of the framers of the Constitution. It was recognized and enforced in every state of the Union, and a departure from it would have been justly deemed an approach to tyranny and arbitrary power, to the exercise of a mere discretion, and to the abandonment of all the just checks upon judicial authority. It would seem impossible then to presume, if the people intended to introduce a new rule in respect to the decisions of the Supreme Court and to limit the nature and operations of their judgments in a manner wholly unknown to the common law and to our existing jurisprudence, that some indication of that intention should not be apparent on the face of the Constitution. We find Article 4 that the Constitution has declared that full faith and credit shall be given in each state to the judicial proceedings of every other state. But no like provision has been in respect to the judgments of the courts of the United States, because they were plainly supposed to be of paramount and absolute obligation throughout all the states. If the judgments of the Supreme Court upon constitutional questions are conclusive and binding upon the citizens at large, must they not be equally conclusive upon the states? Yes. Of course. Why would we need to go through all 50 states and have all 50 states ask the question and have an opinion? Why is it called the Supreme Court? How many times do we actually need to ask the question? Oh, well, that's Idaho. I'm not from Idaho. I'm in California, so that doesn't apply. I'm not interested in that recent comment out there by a member of the bar, and I'm pretty sure he is. I'm used to your verbiage and how you guys make your arguments. You're all drones, mindless drones. I've spent enough time now in this where I'm seeing a pattern of responses, and they're all using the same verbiage and the same arguments. It's almost like they went to the same school and they're taught the same thing, and they all regurgitate the same thing. It's the same arguments from all of these members of the bar. They don't have any outside thoughts of their own. They just regurgitate what they were brainwashed to say. And now that I've been in this long enough, I'm starting to recognize it. And I know how to give rebuttal to it. Because there's a conflict with that argument that they make. So, if the judgments of the Supreme Court upon constitutional questions are conclusive and binding upon the citizens at large, must they not be equally conclusive on the states? If the states are parties to that instrument, are not the people of the states also parties? I mean, kind of be logical in a sense, wouldn't it? If it's declared or deemed to be unconstitutional in one state, clearly it's unconstitutional for any of the states to do it, because we only have but one form of government. We can't sit here and say that in one state they have the power to do this and in another state they don't. I thought it was to form a more perfect union, to ensure domestic tranquility, ensure justice, right? Or establish justice, and to ensure domestic tranquility. That all things being equal across the board throughout the whole union. Okay. So now we look at this here. In the next place, as the judicial power extends to all cases arising under the Constitution, and that Constitution is declared to be supreme. Now remember, we got the declared act of tyranny and the Declaration of Independence. Legislating for us in all cases whatsoever is a declared act of tyranny. So clearly they can't legislate for us in all cases. This is why we have to pay attention to the verbiage here. Extends to all cases arising under the Constitution. And that Constitution is declared to be supreme, the supreme law. It's not the supreme law. It's the supreme law of the land. The supreme law would be the common law, God's law. That's the supreme being. But see, there again, being a little bit misconstrued here, they can take that and go, oh, well, it's supposed to be the supreme law. Okay. That supremacy would naturally be construed to extend not only over the citizens, but over the states. This, however, is not left to implication, for it is declared to be the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. The people of any state cannot then, by any alteration of their state constitution, destroy or impair that supremacy. Exactly. So long as they stay within the scope and authority delegated pursuant to the Constitution of the United States of America, because it has to be pursuant thereof. How then can they do it in any other less direct manner? Now, it is the proper function of the judicial department to interpret laws, and by the very terms of the Constitution, to interpret the supreme law. Its interpretation then becomes obligatory and conclusive upon all the departments of the federal government and upon the whole people, so far as their rights and duties are derived from or affected by that Constitution. Right. So long as their rights and duties are derived from or affected by that Constitution. Our God-given rights don't come from the Constitution. Natural rights and civil rights don't come from the Constitution. Now, political rights do. Because again, natural rights and civil rights have absolutely nothing to do with the establishment, support, or management of the government. The Constitution is the government. So if natural rights and civil rights have nothing to do with the Constitution, how could they be under subject matter jurisdiction under any power delegated under the Constitution? And they can't be affected by anything that's made pursuant to the Constitution, because they're antecedent to the Constitution. They came long before the Constitution. See, Hale versus Henkel says that. So if then all the departments of the national government may rightfully exercise all the powers which the judicial department has by its interpretation declared to be granted by the Constitution, and are prohibited from exercising those which are thus declared not to be granted by it, would it not be a solipsism to hold, notwithstanding, that such rightful exercise should not be deemed the supreme law of the land, and such prohibited powers should still be deemed granted? It would seem repugnant to the first notions of justice that in respect to the same instrument of government, different powers and duties and obligations should arise, and different rules should prevail at the same time among the governed, from a right of interpreting the same words manifestly used in one sense only, in different, nay, in opposite senses. If there ever was a case in which uniformity of interpretation might well be deemed a necessary postulate, it would seem to be that of a fundamental law of a government. It might otherwise follow that the same individual as a magistrate might be bound by one rule and in his private capacity by another at the very same moment. Imagine that. There would be neither wisdom nor policy in such a doctrine, and it would deliver over the Constitution to interminable doubts, founded upon the fluctuating opinions and characters of those who should from time to time be called to administer it. Such a Constitution could, in no just sense, be deemed a law, much less a supreme or fundamental law. It would have none of the certainty of universality, which are the proper attributes of such a sovereign rule. It would entail upon us all the miserable servitude which has been depreciated as the result of vague and uncertain jurisprudence. Mr. S. Blah, 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 blah. It would subject us to a constant dissensions and perhaps to civil broils from the perpetually reoccurring conflicts upon constitutional questions. I know that's what I'm saying. It's like, how many times do we have to question whether or not this is constitutional or not? Just saying. All right, folks. So, I'm going to call it an end there. We're section 170, I believe, of book 1. We'll try and remember that one. Oops. All right, folks. Thank you all for being here. Glad to have you. Thank you're here. Thank you for being here and trying to learn, comprehend this complex bull crap and make it easy, and understand, comprehend what's really gone on here is that subversion of law and sedition and treason and how it happened. Right? Frequent reoccurrences to fundamental principles. We need to return to some fundamental principles that essentially the judicial branch is really there to challenge the constitutionality. Suits between man and a man are supposed to be done at the common law in a common law court and not in any court of the United States. Where are our common law courts? Where are they? All right. So, much love, everybody. Thank you for being here. And if you'd like to help support the channels, if you'd like to do the snail mail type thing, send stuff over to the office, 6477 West Fairview Avenue, Suite C, Boise, Idaho 83704. For the digital side, PayPal, Kirk_Pendergrass at hotmail.com. Cash App is the $, capital K, capital P, EN71. And of course, over on Patreon, Wednesday night workshop, every Wednesday night right now, 5 p.m., 4 p.m. Pacific, 5 p.m. Mountain, 6 p.m. Central, 7 p.m. Eastern time. And I send that out in a private message. So make sure you patrons don't share that with anyone else. That's for you only, right? So we'll see you patrons over there Wednesday night for Wednesday night workshop. All right. Keep the prayers going. Pray for our U.S. Marshals doing their tough job, doing what they're doing, the military, President Trump. And of course, pray for our enemies. Hopefully they have a change of heart, right? Let's see what happens, right? And again, I want to thank my team members, and those behind the scenes. Thank you for being here, and thank you. I see a few of you on. Thank you for being part of the team and actively engaged and doing what we're doing. Okay. And of course, all of the silent people behind the scenes here make all this happen. Much love, everybody. Have a wonderful night, and we'll see you back here on Friday night, fun night. Unless you're on Patreon. All right. See you Wednesday night there. Other than that, have a wonderful night, everybody.